Hi guys, welcome to my channel, The Legal Affair, with myself, Attorney Bay. As always, we talk all things law, and our conversation today is on lease agreements. Please, of course, do remember to subscribe to our channel on YouTube, The Legal Affair. You can also follow us on social media, The Legal Affair. You can also follow me on TikTok and Twitter at attorney_bay. That's at attorney_bay. So, lease agreements or rental agreements are, of course, contracts. And like every other contract, I think it's quite important that you go through the contract, you read the contract, you ensure you're comfortable with the terms and conditions of that particular contract before you sign that particular contract. I think it's advisable also that before you sign a contract and you want to make changes to that particular contract, rather make those changes before you sign the contract. Should it occur, of course, that you sign a contract and you want to make changes to the particular contract, you can have an annexure or an addendum to that particular contract. That annexure or addendum will, of course, set out the changes that you'd want to make to that particular contract. And it is important that you bear in mind that when it comes to making changes after signing a contract, all the parties in a contract are required to consent or to agree to make the changes. So you aren't unilaterally or only on your own make changes to the contract. It must be that always that the parties in the contract all agree to the changes of the particular contract before you can actually make changes to the contract. I think when it comes to lease agreements or rental agreements, what is also important is actually an inspection of the particular property before you sign your rental agreement. I think it's of assistance to actually inspect the property, go to the property, see if there are any damaged items, specifically when it comes to property that you are leasing with furniture. So when you do lease a property that does have furniture, I think it's quite important that you actually inspect the furniture in question and you inspect the property that you are leasing. It does help also to have a list of defective goods or items that are broken when you occupy a property, and list those items and in that particular contract to say, when you occupy that particular property on a certain date, these are the items that were defective or they were non-functional. There are quite important number of important clauses when it comes to lease agreements, rental agreements. One such clause, for instance, is a clause that deals with a deposit. Now, deposits are payable in some instances and they aren't payable in some instances. It does, of course, depend on what the landlord and the tenant agree to. But in an instance where a deposit is payable, it is important that as a tenant you are aware that your landlord has a legal obligation to ensure that your deposit is kept in an interest-bearing account. And upon termination of your lease agreement, your landlord has an obligation to pay over all the interest that has accumulated in that interest-bearing account. So it is a legal obligation, of course, for landlords to ensure that when tenants do pay deposits, rather, that deposit is kept in an interest-bearing account. Now, another important clause when it comes to contracts is a footstool clause. So what footstool clauses are, they are clauses that set out to provide that when you occupy a property, you occupy the property as is. What is also important are latent and patent defects. Now, what a latent defect is that it is a defect on a particular property that is not easily visible, and it is also a defect that you usually see when an inspection is done by an expert. Now, latent defects differ quite a lot from patent defects. So, patent defects are defects that you can easily see. So, for instance, a cracked window or a broken cupboard. Now, when it comes to the footstool clause and the latent and patent defects, landlords have an obligation, according to the Consumer Protection Act, to disclose all latent defects on the property. So it must be that if there is a latent defect on the property that you are leasing, your landlord must bring it to your attention what that particular latent defect is. Now, you must also note that, of course, with the footstool clause, it means that you occupy that particular property rather, as is. So, but for the disclosures of the latent defects, when a footstool clause is incorporated in an agreement, it essentially means that you occupy that particular property as it stands. Now, another important clause when it comes to contract are suspensive conditions. So, put very simply, suspensive conditions are conditions that suspend a contract. So, in order for contracts to remain valid and binding, those suspensive conditions must be fulfilled or must be met. So, for instance, you could say, as a tenant, you want a week before you occupy that particular property for the landlord to have it cleaned, and painted, so forth. So if it so happens that you put such a suspensive condition in your lease agreement and your rental agreement, should it occur that your landlord doesn't, for instance, clean or paint the property in question, it would mean that your contract is suspended. So it's no longer a valid and binding contract because the suspensive condition isn't fulfilled. So I think when it comes to suspensive conditions, it's quite important that when you choose or elect to incorporate a suspensive condition, my tongue is playing, suspensive conditions in a contract, you do ensure that those suspensive conditions are conditions that either the landlord or the tenant is able to meet. So set a realistic suspensive conditions in a contract, because should suspensive conditions not be met, of course, this means that a contract is no longer valid and binding. Another important clause when it comes to contracts is a special conditions clause. Now, special conditions clause in some instances is included in the lease agreement, and in some instances it isn't included. What a special conditions clause does is that it allows either the landlord or the tenant to put special conditions to that specific rental agreements or lease agreements. And special conditions can, of course, vary depending on the property in question that you would like to lease. So, for instance, as a tenant, you can request that a landlord has a special condition that the property is cleaned, or they grant you access prior to occupation, or that the tenant is out before a particular date, and so forth. So special conditions are, of course, conditions that aren't always in rental agreements or lease agreements, and it is at the discretion of the landlord and the tenant on what type of special conditions they want to incorporate. I think it is quite important that if you do, of course, incorporate special conditions, you must incorporate conditions that are realistic and attainable, similarly to what you would do with a suspensive condition. Now, when it comes to rental disputes and disputes between landlord and tenants, it is something that is quite common. Of course, if you do have a dispute with your landlord as a tenant, or if you're a landlord and you have a dispute with your tenant, you can always refer your dispute to the rental tribunal. Now, when it comes to a rental tribunal, the role that the rental tribunal is quite extensive. They adjudicate or they mediate on disputes between landlord and tenants. They adjudicate on issues relating to the cutting of power or any other access when it relates to a landlord and a tenant. So, for instance, when a tenant is limited access to the property in question, when the electricity or water supply of a particular property that is being leased is cut, such a dispute can actually be referred to the rental tribunal. Now, if you do opt to, of course, refer a dispute to a rental tribunal, it is important that you actually refer the dispute to the correct tribunal. If you're in Johannesburg, for instance, you must refer your disputes to the Johannesburg Rental Tribunal, and if you're in Pretoria, you must refer the disputes to the Pretoria Rental Tribunal. So always ensure that if you elect, of course, to refer a dispute that relates to rental agreements, refer the dispute to the correct rental tribunal. When it comes to disputes relating to landlords and tenants, of course, you can actually check out the website of the Rental Tribunal. The role that they play is quite extensive when it comes to disputes between landlords and tenants. The application or the process that should you want to refer to a rental tribunal is a process that is done online. The Rental Tribunal website actually has forms that you complete, and you just send the forms once completed, of course, to the Rental Tribunal, and then they'll adjudicate. Of course, once they adjudicate, they decide on a particular outcome between the landlord and the tenant, and it is important that the landlord and the tenant actually note what that particular outcome is. And of course, if you are either a landlord or tenant, or you refer a dispute to the rental tribunal, you must notify the other party of that particular dispute. So I think the rental tribunal plays a very important role in the rental or the leasing space, because not everyone, of course, can afford the services of an attorney. So should you find yourself in a position that you are in dispute when it comes to either the payment of a deposit, when it comes to access to property, when it comes to services that are being cut in a property, when it comes to various issues when relating to rental disputes, you can, of course, remember to refer that dispute to the rental tribunal. Important, of course, is that the tribunal you must always refer the dispute to the correct tribunal, and that the application process relating to rental disputes is an online process that you can actually check out on the website of the Rental Tribunal. We hope you enjoyed our episode today, and please, of course, do remember to subscribe to our channel, The Legal Affair, on YouTube.